Can I be fired for refusing to do something illegal? Imagine this. Your boss pulls you aside and tells you to do something you know is wrong. Maybe they ask you to lie on financial records, ignore safety rules, or fire someone because of their age or gender. You hesitate because you know it's illegal. You refuse. The next day, you're called into the office and you're fired. It feels like punishment for doing the right thing. The big question is, can my employer fire me for refusing to do something illegal? This situation is more common than people think. Workers in industries from healthcare to construction, finance to retail, face pressure to break laws. Employers sometimes retaliate when employees stand their ground, but the law is clear. You cannot legally be fired for refusing to engage in illegal activity. In this video, we'll explain how federal and state laws protect workers in these situations, what retaliation looks like, and what steps you can take if you're punished for saying no. The at-will rule and its limits. In most of the U.S., employment is at will. That means employers can fire employees at any time, for almost any reason, or for no reason at all. But one important exception exists. Employers cannot fire you for reasons that violate public policy. Refusing to commit an illegal act is one of the clearest public policy protections. Courts in many states recognize this. Even if you're an at-will employee, being fired for refusing to break the law may give you a wrongful termination claim. Example: a truck driver is asked to falsify driving logs to exceed federal safety limits. He refuses and is fired. In many states, that's unlawful under the public policy exception. OSHA and safety-related refusals. The Occupational Safety and Health Act, OSHA, protects workers who refuse dangerous assignments that violate safety rules. Section 11C makes it illegal for employers to retaliate against workers who report unsafe conditions, refuse work they reasonably believe could cause serious injury or death, file OSHA complaints, or assist in investigations. Example: a construction worker is told to climb scaffolding without required safety gear. He refuses, citing OSHA rules. If he's fired, that's unlawful retaliation, and OSHA can order reinstatement and back pay. Wage and hour violations. Under the FLSA, the Fair Labor Standards Act, FLSA, sets rules for minimum wage and overtime. Workers who refuse illegal practices like working off the clock or accepting sub-minimum wages are protected. Example: a server is told to clock out but keep cleaning for free. She refuses and she's fired. That's retaliation under the FLSA because refusing unpaid work is protected activity. Civil rights laws. Title VII, ADA, ADEA. Federal civil rights statutes make it illegal to fire someone for refusing to discriminate. Title VII protects workers from being forced to discriminate based on race, religion, sex, or national origin. ADA protects workers from being ordered to violate disability rights. ADEA protects workers from being told to fire or mistreat older employees. Example: a manager tells a supervisor to let go of the older staff and hire younger workers. If the supervisor refuses and is fired, that's illegal retaliation under the ADEA Corporate Fraud and Sarbanes-Oxley, SOX. The Sarbanes-Oxley Act, SOX. Protects employees in publicly traded companies who refuse to falsify financial records or participate in fraud. It's a whistleblower law that ensures workers can say no without losing their jobs. Example: an accountant refuses to manipulate earnings reports. She's fired. Under SOX, she can file a retaliation claim, seek reinstatement, and recover damages. Other whistleblower laws. Dozens of whistleblower statutes exist across industries. They protect workers in energy, transportation, healthcare, finance, and more. These laws all share a principle. Refusing illegal conduct is protected. Example: a nurse refuses to alter patient records to cover up errors. She's terminated. State and federal whistleblower protections may apply, ensuring her firing is unlawful. The role of the NLRA. The National Labor Relations Act, NLRA, protects concerted activity. If workers collectively refuse to follow illegal instructions, their actions may be protected. Example: warehouse workers are told to handle toxic chemicals without training. They collectively refuse. Firing them would violate the NLRA, as they engaged in protected activity. How retaliation is proven. If you're fired for refusing to do something illegal, proving retaliation involves showing you were asked to perform an unlawful act. You refused. You were terminated shortly after with no legitimate reason. Timing and documentation are critical. Courts often look for whether the employer's stated reason for firing is inconsistent with the record. Example: an employee with strong performance reviews is suddenly fired after refusing to falsify records. The suspicious timing supports retaliation claims. State public policy protections. While federal laws cover specific situations, state courts often fill the gaps with public policy doctrines. California recognizes wrongful termination if an employee is fired for refusing to violate state or federal law. New Jersey. The Conscientious Employee Protection Act, CEPA, is one of the strongest whistleblower laws in the country. Montana requires just cause for termination after probation, offering broader protection than at-will states. Example: in New Jersey, a healthcare worker who refuses to participate in Medicaid fraud is fired. Under CEPA, she can sue for damages and reinstatement. Real-world cases expanded. Case 1. Safety. A refinery worker refused to bypass safety valves. He was fired, but OSHA ordered reinstatement with back pay. At Case 2. Finance. An accountant at a public company refused to falsify financial data. The SEC and Department of Labor enforced protections under SOX. Case 3. Healthcare. A nurse declined to destroy patient records that revealed malpractice. The court sided with her, citing state whistleblower protections. Case 4. Construction. A worker refused to haul toxic waste without permits. He was terminated, but a state court found wrongful discharge under the public policy exception. These cases highlight that refusing illegal acts is one of the strongest legal protections workers have. What workers should do. If you're pressured to do something illegal and fear termination. 1. Document requests. Save emails, texts, or notes about what was asked. 2. Say no clearly. State that the request violates law or policy. 3. File a complaint if needed. Depending on the issue, contact OSHA, the DOL, the EEOC, or state whistleblower agencies. 4. Act quickly. Many laws have short deadlines. OSHA retaliation claims often require filing within 30 days. 5. Seek legal advice. Attorneys specializing in employment law can help file claims and protect your job. Example: a retail worker told to falsify sales numbers refuses. She's fired. With legal counsel, she files under state whistleblower laws and wins compensation. The human impact. Refusing to commit illegal acts can feel risky. Workers worry about losing income, health insurance, and stability. But long-term, saying yes to unlawful conduct can destroy careers, reputations, and even bring personal liability. That's why laws are designed to back up workers who choose integrity. Example: an employee who refused to dump chemicals illegally lost his job, but with legal support, he not only regained wages but also preserved his reputation as an honest professional. The bigger picture. Workplaces depend on trust and legality. If employers could fire workers for refusing unlawful orders, laws protecting wages, safety, and civil rights would collapse. That's why federal statutes and state public policy strongly prohibit such retaliation. Workers who know their rights are less vulnerable to pressure and exploitation. So, can your employer fire you for refusing to do something illegal? The short answer is no, not lawfully. At-will employment gives employers broad power, but refusing illegal activity falls under strong public policy and whistleblower protections. OSHA shields safety refusals, the FLSA. Protects wage complaints, civil rights laws ban discriminatory orders, and whistleblower statutes cover fraud and misconduct. States add even more protection, especially through public policy doctrines. The bottom line, standing up against unlawful orders may cost you your job in the moment, but the law is on your side. You can fight back, seek reinstatement, recover damages, and clear your name. If this video helped clarify your rights, share it with coworkers. Knowledge empowers workers to say no when employers cross the line.